The Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin, and we're all in for a treat because I'm joined today by my colleagues, Justice D'Angelo to my right and Justice Smith to my left. We will be hearing 5 cases today. I don't know if counsel for cases 4 and 5 are here, but we will talk about what the time assignment will be for that when we get to it. Our ordinary rule is 15 minutes per side with no rebuttal. We have read with some care your briefs and generally know the facts of the cases, so you may want to get right into your argument, but the time is your own and you can use it as you will. The first case we will hear this morning, I believe, is Commonwealth versus Burgos, and I believe we will hear first from Attorney Zendrowski.
Yep, that is correct. So, good morning, may it please the court. This appeal concerns 2 issues stemming from a Gardado, essentially. And so the first is the trial judge's failure to instruct the jury regarding the Commonwealth's burden of proof regarding the lack of a firearms license was not a harmless error because the defendant had challenged the Detective Silvera's credibility.
So is it your reading of Bookman that if the defense challenges the credibility in any aspect whatsoever of the officer, that's it?
I would, that is my reading generally, I would agree with that. But I would also say that essentially how this testimony came in was Mr. Burgos testifying that Detective Silvera was somehow manipulating the tape, and so this is some sort of allegation that he was manipulating the physical evidence before trial. So I think that there's at least some more connection than a general sort of challenge towards credibility.
When the defendant testified and talked about his, I'll call it a confession, I know it wasn't actually a confession, but his statement,
right.
There was no discussion at all during that testimony about the licensing issue, correct? For example, he didn't say, I never had a license. There was no discussion about that whatsoever.
Right, yeah, there was no discussion. There is just that one little bit of Detective Silvera saying, I confirmed he didn't have a license. That's kind of the entirety of any reference to a firearms license in evidence at that trial.
So if the defendant's theory, based on his statement and on closing argument, was that Mr. Burgos sort of just grabbed the gun off another individual, why should licensing be an issue in this case at all? Why isn't it now harmless error?
Well, I don't know that Mr. Burgos' testimony wasn't consistent with that, where Mr. Burgos had testified. It kind of precluded him from making that self-defense claim, but he testified he never handled a firearm. He never touched a firearm whatsoever. So he sort of distanced himself from the police. He said he told the police what they wanted to hear because he thought they would let him go if he did. So he basically disavowed pretty much everything he said to the police.
So doesn't that make it even more, I don't know if there can be more of a harmless error, but doesn't it make it more of a harmless error? Under his theory of the case, he doesn't touch a firearm at all. Under his statement to the police, it's that he grabbed a gun off another individual in self-defense, and therefore licensure wouldn't be an issue in that situation either. So why isn't this harmless error?
Well, I think that the Commonwealth would still have to prove that he didn't have a firearms license regardless of the defense because it's their burden of proof. And so given that Detective Silvera is out there testifying that he confirmed that there wasn't a firearms license, so I think that they're staking a claim. They're attempting to, well, it wasn't an issue back then. It was right before Gardado, but that's sort of their evidence on that point. And so I think the jury needs to be instructed on all elements of the crime, or should have been, in hindsight. I think that there was some evidence that it was a credibility contest, both through Mr. Burgos's testimony, directly putting kind of Detective Silvera's credibility on the line. I think that in closing argument, the Commonwealth also spoke of the defendant being not a credible witness and Detective Silvera being a credible witness. And so I think that there was this issue of credibility that was live. I think also that there is, well, this was part of his testimony. I think that basically the error stems from the lack of instructions to the jury. So I don't think we need to evaluate sort of any more than did the defendant raise the credibility, and I think his testimony did. I don't think we need to go any further on that to explore how effectively it raised credibility, anything to that extent. I think that it was raised. I think that it was a live issue for the jury to resolve, and so then the missing instruction was not harmless error. The second portion of the argument is essentially there's a substantial risk of a miscarriage of justice from the lack of objection to the testimony. I did confirm that the defendant did not have a firearms card. And so essentially I think it's close, but I don't think that this is testifying from Detective Silvera's personal knowledge.
But that wasn't the objection. The objection had nothing to do with hearsay, which might be why he got that information. The objection, frankly, was that it was beyond the scope, which was a good objection because it wasn't talked about. But then it was withdrawn. So what do we do with that?
That's why I'm saying the substantial risk. I felt that the substantial risk of beyond the scope or substantial risk of a lack of foundation. I thought that it was, when there's no objection, we go to that substantial risk standard. So that's sort of where I end up with that.
How do we know it's a lack of foundation? The officer says, I learned about it, basically, or I found out. Isn't that enough for a foundation?
I think I confirmed doesn't necessarily go to personal knowledge. Where did he confirm it? If he confirmed it from kind of a CGIS type database, or if he'd asked the defendant, there's no evidence of that. I think that would have probably been sufficient had that been the evidence. But I think that's also sort of an issue that's pending right before the SJC right now with Quentin Smith, sort of how does the Commonwealth prove a lack of licensure with what kind of entries are people making into CGIS records of people's birthdays? Is there a common identity? And so that isn't exactly present in this case, but I think that it kind of shows how important that foundation is to exactly how the Commonwealth comes to find out that someone doesn't have a license.
You're arguing substantial risk. Are you essentially making ineffective assistance counsel argument?
I don't think it was necessarily ineffective assistance at this point just because it was pre-Guardado. So I think that the importance of this exchange just was not particularly apparent to anyone then. I don't think the Commonwealth would have done it that way. I think defense counsel might have done some different objections had people known that this was actually going to be an important issue and it was going to change dramatically. So.
Could this have been a strategic decision by counsel, though, because he didn't want the jury to hear how the officer knew about the license issue? And if that's the case, I know this is pre-Guardado, and I don't think there's been a case that sort of gets into that. What do we do?
Right. Oh, I think that I would argue that essentially, really, without more information, it couldn't have been a strategic decision for trial counsel because the ins and outs of this weren't apparent at that time.
Well, it was also not important in the case. It's irrelevant to the case the way it was instructed. I mean, if he's not raising the defense, then, you know, right, if he knew that that was an essential element of the crime, if the lawyer did, and this evidence comes in on that, then you have an incentive to object on any grounds that you can come up with, including lack of personal knowledge, right? But he wouldn't have had that incentive at a time when it was not an element of the offense and didn't have to be proven by the Commonwealth.
Right, that is correct. It's sort of, I think with Bookman and Guardado, the clairvoyance exception, it's sort of a bit messy because it's coming in with a substantial risk kind of issue, but it is sort of in that same realm. I think that's really all I have unless there are further questions.
The discharging count, discharging the firearm?
I would concede that that would survive kind of any Guardado issue.
I want to be sure. Very good. Thank you.
Thank you very much. Excellent argument. We will hear next from Attorney Cohen.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. Although it was certainly error for the trial judge to fail to instruct on the element of licensure, that error was harmless. That is because the error did not contribute to the verdict, where Detective Silvera's testimony that the defendant did not have a license or an FID card was uncontested, at least in substance. And while I do agree that there was a credibility issue raised through the defendant's testimony, I would argue that while Detective Silvera testified, there was no challenge to his testimony during cross, and it was certainly not a combative cross-examination. I think through the defendant's testimony, while he did raise the credibility of Detective Silvera, it was the defendant's own credibility that suffered through his testimony.
What difference does that make under the Bookman exception? Is there anything in Bookman that says the credibility has to be directly challenged on cross, or is it just credibility challenged?
It does say a credibility challenge, Your Honor, but I would argue in this case the defendant was entitled to cross-examine Detective Silvera more thoroughly on what happened during the interview. He could have cross-examined Detective Silvera on his testimony about licensure, and none of that was challenged. So I would argue, while a credibility issue was raised, I would also say that based on the jury's verdict, it was clear that it was, again, the defendant's credibility that was at issue, where they clearly didn't believe he never possessed a firearm or ammunition in order to convict him.
You agree that the detective's testimony regarding licensure was beyond the scope of the direct and cross, correct?
I do agree.
So what do we do with the fact that the Commonwealth didn't even introduce this evidence in the direct testimony, and it only came out, frankly, improperly, but the objection was withdrawn? Is there anything we should take from that?
I don't think so, Your Honor. I would say that it was clearly an objection on procedural grounds. It wasn't to the substance of the testimony, and while I agree that the clairvoyance exception puts me on different footing, certainly, I think in this case where the objection was withdrawn, no other objections were raised, I would say that it doesn't change the calculus.
But it wasn't important at the time.
That's correct, Your Honor.
So who knows how it would have been litigated if it was an element of the offense, which of course we now know it is.
Sure. And I would also speak to Justice D'Angela's point earlier about the theory of the defendant's case. I think that does come into play as well, where at trial at least, he's claiming that he never touched a firearm whatsoever. So I think that the element of possession is clearly the element that is at issue for all of those charges. And that's really what it seemed to come down to for the jury.
Are you familiar with our McCrae case?
No, Your Honor.
Are you familiar with our line of cases that says that when an element of the offense hasn't been instructed on, that the only time it doesn't create a substantial risk of a miscarriage of justice is when the evidence and or the jury's verdict ineluctably lead to the conclusion that they would have found this beyond a reasonable doubt. You're aware of that line of cases?
I'm aware of yes, Your Honor.
That rule. How can Bookman fit with that? On the one hand, we're saying it's a substantial risk of a miscarriage of justice if it doesn't ineluctably lead to the conclusion. And obviously, this sort of offhand comment by the officer with no, without explaining anything more, it supports, obviously, a conclusion, but it doesn't ineluctably lead to it because the jury doesn't have to think anything of it. How can it both create a substantial risk and be harmless beyond a reasonable doubt at the same time? And I recognize this is a problem created by the SJC, whose cases we have to follow. But I can't figure out how you can have both be true.
Sure, Your Honor. And I think in my analysis, I purely followed Bookman because I think that's really the only case on point to this particular issue, given the situation with Guardado. But I do think, again, this wasn't a contested point. And I agree with Your Honor. I understand the court's point that with clairvoyance, this testimony may have been colored in a different light. But I think as things stand, again, clearly where the defendant's theory of the case was that he never possessed the firearm, and that was the crux of what he was trying to relay to the jury to kind of rehabilitate his previous statements to police. I think that was the point at issue.
Do you think the two rules can't be squared? I understand we have to follow what the SJC says, but do you think that the substantial risk question is no longer that what the courts have said about substantial risk is overruled by Bookman?
Well, I suppose I considered substantial risk, at least for the second issue, and I had a hard time arguing substantial risk in that case, because I do think, at least on the fourth prong, I can't argue that this was a tactical decision where the clairvoyance exception is there. I can't argue that. And I think in this case as well, if I don't have this particular testimony from Detective Silvera, of course I can't meet the element.
Well, of course.
So I think, it would be hard to analyze the case in line with substantial risk in these sorts of circumstances.
Okay.
If the court has no further questions, I'll rest on my brief.
Thank you very much. Also an excellent argument. The case is submitted. The next matter we will hear is number 23-1127. This is Commonwealth versus Grant. We will hear first from Attorney Holinsky.
May it please the court. Good morning, Your Honors. Justices D'Angelo, Rubin, and Smith. I want to apologize up front. I've never really done this in 20 or so times before you, but in rereading my brief, the typos are awful, and I really apologize for that. It's not like me. So just wanted to throw that out there. I'm sorry for the writing. It's usually much better than that. I'm not sure what was going on. In any event, this is an unusual case. Trying cases for, going into my 25th year of practice. Can't say this has happened before, which leads me to what do you do when it does happen? The case law is clear. And by the way, there's not a lot of case law out there unless you're going extra-jurisdictional. There really is not a lot of guidance in terms of what to do. I understand it's developing, probably why we're here on interlocutory appeal. My understanding and what I've argued to you is that a mistrial that carries with it a presumption of retrial is one in which the defendant is somehow involved in that. So the defendant takes a look at the environment, doesn't like what's going on, and asks for a mistrial or really a retrial, given that it's a presumption of retrial. We're 2 stages beyond that, in my view. Now, I was the trial lawyer. I think you figured that out. My issue is that I cross-examined the teenage witness the day before. I have a teenage daughter. I'm used to arguing with teenage girls. In my view, it didn't go great for her. It was hard. It was inconsistent. I did not pull back like I usually do with a child witness. I believe it led to her not coming back the next day. I think it was.
Well, I'm not sure we can go there, Kamal,
a guess.
counsel. Let me ask you this. So when the judge declared a mistrial, your position is that the defendant did not consent to that mistrial, correct?
So the reason why I take that position is because if the definition of mistrial, which I did know at the time, is that it carries a presumption of retrial, then regardless of the word that I used, I don't think I really asked for a mistrial. I asked for a dismissal.
You asked for a mistrial with prejudice twice, correct?
Right, which is, in my view, when I added that word with prejudice, I'm really asking for dismissal.
So you're indicating the defendant is not assenting to a further trial in this matter, that jeopardy should attach?
Well, I think the record is replete with that. I mean,
So when the defendant does not agree with a mistrial, is the judge required to find there's a manifest necessity?
no, I think
Proceed.
This is where the case law is actually developed. I think you'll all agree. I don't know. But this is a manifest necessity case. This is a case where we have to look at what could the judge have done other than terminate the trial.
Well, before we do that, my question to you, though, is did the judge do that? Or did the judge operate under, when a case is mistrialed without prejudice, there could be 2 reasons. The defendant could move for that and agree to that.
Yeah.
And then the test essentially is whether the prosecutor goaded that, whether there's prosecutorial misconduct. And that's what seemed what the judge focused on in her motion to reconsider. But there's another scenario when the defendant does not assent to it, the judge must find there's a manifest necessity. Are you saying the judge implicitly did find out, the judge never sought to determine whether there was manifest necessity?
The latter. I mean, I think she made some comments about, do you want a capias, or, she made some fleeting comments, but like, there are so many things that could have been done here other than ordering a mistrial. Keeping in mind, this is the second time we've been in court. 83-year-old defendant, teenage, I mean, there's a lot of things here that the
record's a bit unclear. The record's a bit unclear as to when your expert was available, when he or she wasn't available. The expert's unclear as how much time the expert would have taken.
Yeah.
There's reference to a juror being unavailable, but I don't see support for that in the record. Can you tell me where the support for that there may be a juror unavailable for that Friday?
Yeah. It was during, I think it was during, I don't really know. I went and looked for it myself. And
You can't tell me. You referenced it and the judge agreed with you in the transcript, but as you stand here, you don't know exactly
Yeah,
what.
I went back and looked at, I mean, it was 2 days of jury selection, so it's hard to find that one reference. No, but as far as the juror not being available, we had alternates. I mean, we
Was the
did have
judge
alternates.
available?
Say again?
Was the judge available on that Friday?
Yeah, everything was ready to go. I mean,
You didn't say, no, I want this jury, let's keep going.
I'm not required to.
I understand, I'm not exactly sure what counts as consent and non-consent.
Well, I think the rule is clear, and that's in my brief, is that unless there's an affirmative consent, there is no consent. That's the law, right? I mean, that's a tough one, but that is the law.
All right, so now let's talk about manifest necessity. What does that look like in the case of a prosecution witness not showing up?
I have so many problems with this, Your Honor. You can't have a complainant that just keeps not coming back. Like, how many times are you going to do this? Like, okay, so we retry the case. I say, okay, let's retry the case. She does it again. How many times can she redo it? You know, where
Well, in
we
this
say stop.
in this situation, it was one morning.
I get that. But the argument is, like, if we allow it this time, how many times? If we
I'm
allow-
asking a different question. I'm
Manifest-
asking
manifest
what is manifest necessity?
Yeah.
A prosecution witness doesn't show up, critical
Yeah.
witness doesn't show up. When is
So-
that manifest necessity and when is it not?
I think it's manifest necessity when, what the case law says, when you run out of options. She didn't consider striking the cross and asking the Commonwealth to call its next witness, which that would have been my preference. You know, that's what she should have done.
And so the trial goes forward and presumably you move her a required finding and you get it.
Yeah.
Because there's no testimony against your client. Okay.
That's the way it should, in a perfect world, with the law is the way that it is, it's exactly what should have happened.
But you didn't ask for that.
I don't need,
You asked for a mistrial immediately.
I asked for a dismissal, technically,
You said a mistrial with prejudice,
which is a dismissal.
okay? But it's
Yeah.
not, because a dismissal in the middle of the case is not what's appropriate. It would be a mistrial with prejudice. I'm not faulting you for asking
Yeah.
that. But at that point, you could have not asked for a mistrial. You could have said,
Right.
Judge, I move to exclude the testimony
Yeah.
of the witness. Let's continue on.
Fair enough. I absolutely could have said that. Like I said, this was uncharted territory for me a little bit.
Sure.
But for sure, that would have been as far as the record's concerned, the best thing for me to do is to say, Your Honor, I move to strike the blah, blah, you know, that would have been perfect. I think we'd still be here, but I think that would have been the way to go. But there are other options. There was my expert witness who, in July, when we were called for trial, had to go to an emergency surgery. I think it was like a senator's son or something like that. It was some big important surgery that he had to go to. I got yelled at.
But he was there for the trial. Let's stay focused.
Right, he was in the back of the room.
Right,
you know?
and there's a line in the transcript, he's lined up for tomorrow. Does that mean he was available to testify, or he was otherwise engaged?
He was ordered to be there the entire trial because of the last one.
So your answer is he was available to testify on Thursday?
100%. If somebody had said, Attorney Helinski, do you want to call your expert out of order? I would have said, please do that.
Well, there was some discussion about that. It just
Right.
wasn't very conclusive on the record.
He had another thing that he had to get to that afternoon.
Okay, but why is all right, so the judge decides, all right, I'm not going to grant a mistrial, we'd like to call your witness, and you say, he can't, he has to be someplace else. Can the judge then declare a mistrial? Is that a manifest necessity?
No, because there's other options. It's not just giving her to the next day or just calling the expert. You can just continue it. I mean, think of it this way. It took 2 days to impanel.
Yeah, but you didn't want to, I assume, continue it to the next day, because by the time this wraps up,
Yeah.
the prosecutor has at least claimed that she'll come in the next day.
Yeah.
Right, that's much worse for you than just put the final witness on and then what was your expert going to testify about if there was no testimony from if it had all been struck, what is there to say?
Yeah, I mean, I can say, just to back up to your last issue about, well, the complaint is going to come tomorrow, that's worse for you. I didn't view it that way. This was going exactly how I wanted it. I saw especially with my expert coming on after, there were no circumstances in which I thought there was going to be a conviction in this case, none. The expert was going to say, to answer your question.
Hold on, counsel. I'm sorry, I'm interrupting here.
That's okay.
When the prosecutor said she can be here tomorrow,
Yeah.
there was nothing out of your mouth like, okay, let's go, we'll see you tomorrow. You didn't want that on the record.
Let me just be clear. My position this entire time, after the prosecutor walked in the morning and said, hey, case is gone, I don't know what to tell you, we're done here. right, was to stand back and let it happen.
Well, it was strategic.
If the judge looked at me and said, what do you want? I said, essentially, I want this case dismissed now. That's what I want. That's what I want.
You didn't say that. You said mistrial with prejudice.
But I inartfully, but I think given that mistrial, it's the wrong word.
What is with prejudice? I mean, I don't understand the difference. I mean, I understand
Yeah.
the formal difference.
Yeah.
But if it's a mistrial with prejudice, the case is gone. It can't be, it's same as a dismissal in practical effect. It can never be prosecuted.
Right. Which is the same as a dismissal with prejudice. It's literally identical, you know? It's gone, you know, it's gone. Unless the dismissal was appealed, I mean, it leaves that open to the Commonwealth, of course, and that goes for a mistrial without prejudice, with prejudice also.
So we'd be here with the burden the other way, talking about the exact same
Exactly,
question.
exactly. So, you know, look at it this way. Like, when you're talking about manifest necessity, it took 2 days in July to pick a jury, which we didn't even get. I think we got 4 people. Then it took 2 days to get 8 people. What's 1 day continuance? I mean, when you're talking about the hardships here and putting out the jury, we've got 8 people. We can easily use an alternate. I mean, what's the harm in just kicking it a day? If she's really going to come back.
But does the record support you supporting that approach? That's where it's a little bit hard to discern from the record, because you're talking about expert, you're talking
Right.
about Friday.
Right.
It's hard for us to know if that really was a possibility. It's hard for us to know if the judge even carefully considered that.
And I think that's the issue right there. It's not my burden, it's the judge's burden to consider the alternatives. If she wanted to have a conversation with me about it, I probably would have agreed. But as I said, I sat back because it's not my duty to sit there and craft a reason. I came for trial that day, as did my
No, I
client.
understand it's not your duty, but when you're representing things that essentially indicate you're not agreeing to continue with the trial, then that may factor into the judge's conclusion, her consideration. It doesn't appear to me from the record that you are saying, let's go tomorrow.
I don't think it's appearing either way, because the judge never asked me. Like, she never said, Attorney Helinski, what's your position? Attorney Helinski, what's your position? She said, what do you want? And I said, I want this case to go away. That's what I said to her in so many words. And that was literally all that was asked of me the entire time. And so, and that's exactly, you know, what the case law says doesn't provide for retrial.
Let me ask you, in a filing, I might have been before the first justice,
Yeah.
you state that in a conversation with the ADA, she said she was moving for mistrial, because she references there maybe have to be a mistrial,
Yeah.
then you move for mistrial with prejudice, and you reference that she'd moved where she hadn't said the words move. But essentially, was there a conversation where she told you the Commonwealth was moving for a mistrial?
The conversation was, this is the Oregon versus Kennedy goading issue. She can speak better to it. You know, we're on good terms. We've always been on good terms. She came in and frankly said, I got a call. The judge said, when did you find this out? She said 15 minutes ago. In fact, we learned in the transcript that it was actually the night before, because they'd had conversations about trying to get her.
Before you went into the court that day, do you remember, as you wrote in a filing, whether the ADA told you that she was moving for a mistrial? Yes or no?
Yeah, I'll be honest with you, I don't remember, but I can tell you that the tone of it was, hey, complainant's not on board, mom's not on board anymore. In fact, she went to school. I'm going to have to dump the case. That was the...
Let me ask you another question. If indeed this case may turn on a finding of manifest necessity, is it appropriate to remand to the court, or is it appropriate for us to consider whether the record supports it?
So I put some thought into this. I think the remedy should be that the court did not exercise manifest necessity, and that dismissal is warranted, because had she considered manifest necessity and other options, she should have stricken the testimony. The best thing that could have been done, what should have been done, is she struck the testimony and she asked the Commonwealth to call its next witness and move forward with the trial. That's the ideal situation. That's what should have been done. She didn't do that. If we project into what should have happened, you know, that leads in a motion for a quad finding. Yeah.
Your time has expired, but I have one question. Did the Commonwealth have another witness?
Done.
And would you then have put on your expert?
Yeah.
What if the judge had struck all the testimony like you
You
suggest
asked me
was an
that.
alternative?
Yeah,
Then-
you asked me that.
Yeah,
What could
but
he
you didn't
testify
answer
to?
me. What would you have done then?
Very easy to direct that. So he could have testified, have you researched materials? Yes, I read the DCF, I read blah, 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 blah. I mean, most of the time, witnesses are sequestered anyway.
Why would you have him testify if there was no Commonwealth case? I don't understand that.
Oh, I wouldn't have gotten that far. It would have been a motion for a required finding. He would never, you're saying if,
If one of the alternatives the judge should have considered
yeah,
was striking the testimony of the teenage witness.
Yep.
Was there any other testimony? Was there
No.
parental?
The mom was going to come in, but she also said no.
Oh, I see, that same day.
But respectfully, I think you're conflating two things, because if it's struck, the case is going to be required finded, right?
Then you're not going to call your witness.
Right, but if it's not,
So your witness is irrelevant.
it's relevant if she grants the continuance. So if,
No, I agree with that.
right,
Okay, I see.
like, if she doesn't strike it, that's the point.
Okay.
Yeah.
So your time has
All
expired.
right, thank you, Your Honors. Happy holidays.
Thank you. You as well. We will hear now from Attorney Knight.
Good morning. May it please the court, Erin Knight on behalf of the Commonwealth, asking this court to affirm the judge's allowance of the Commonwealth's motion to retry. I'm also joined today by the trial prosecutor, Colleen Page. I think that the easiest way to determine this case is a plain and simple reading of the transcript and the judge's finding on the Commonwealth's motion. I disagree with my brother that he was looking for a dismissal. He did use the words mistrial. I understand what he envisioned with the words mistrial with prejudice, but once you use that word mistrial, that puts into effect a certain process that the judge must, go through in her head. He didn't ask for a continuance. In fact, he didn't offer any information about a continuance except for the fact that his expert was not available that afternoon. I do believe he said he was not available the next day, and
Why would
I do
he
know
ask for a
that.
continuance?
I'm sorry?
You say he didn't, why would he ask for a continuance?
I'm not saying he had to, but he offered no information further than he wanted a mistrial. He doubled down on the mistrial.
With prejudice is further. I mean, there's no doubt what that means. You agree that that means jeopardy attaches, the case is over.
Correct, yes. But in looking at the case law on this in this context, first and foremost, I don't agree that the Commonwealth was the first to request a mistrial. I think she had said, I realize it may end in one.
I'm not sure what difference any of this makes.
Because when the defendant-
The test is, as I read it from Taylor, he has to consent to reprosecution.
That's not the test is he has to acquiesce to either request or acquiesce to the mistrial.
You've read Taylor. Unless the defendant consents to a disposition that contemplates reprosecution, it says, retrial is permitted only where a mistrial is declared as a matter of manifest necessity.
Sure.
There's no acquiescence rule. He has to consent.
Consent to the mistrial.
No, consent to
Yes, it is consent
reprosecute.
to the mistrial.
Okay, well,
because-
you can tell me what the law is, but I'm going to look it up, and chances are we're going to apply it. So telling me that it's consent to the mistrial when he's asked for with prejudice, you think you can retry him then because that's consent to retrying him? Because I don't see how with prejudice is consent to retrying him.
Fine. If we want to put that aside, then we go to the judge's decision on the manifest necessity if we get that
Yes.
far, which by the
Can we back up a second? Because I think you misstated something, and I do think it matters. On Record Appendix, page 435, this is after you come into court and say you spoke to the witness 15 minutes ago. I do understand that that will mean a mistrial. That's what the prosecutor said. And then the judge says, are you asking for additional time from the court to try to speak to Ms. Watson? No. What are you asking the court to do? I'm just putting it to the court that the Commonwealth has no witnesses here today and leave it up to the court's discretion.
correct.
So you mentioned mistrial first. I do
yes.
understand that that will mean a mistrial.
That's not a request. That is a recognition of what may happen.
So instead of asking, Judge, we're moving for a mistrial, you say, I understand that this will be a mistrial. You see a difference in that?
I do, because at that point, the judge could, in her considerable discretion, make the decision otherwise. This wasn't a request for a mistrial. She, in fact, did say later on in the process that she had recognized that this morning, but then she did ask for a continuance for the next day due to the victim having called back. So while I see what Your Honor is saying, I just disagree because I think it's more of a recognition that this may happen, but she left it into the considerable discretion of the judge, which this line of cases is based on considerable discretion of the judge, and quite frankly, it's a broad discretion of how to end a case when something of this nature arises.
So frankly, my issue with this case is both counsel did nothing and left it entirely up to the judge. And you think that's okay? For both lawyers to just sit there and go, we're not asking for anything, Judge, it's up to you to do what you want. I have no witnesses. They're not coming in. I understand it might be a mistrial, but you do what you want, Judge. That's how this was left, and that's okay from both sides.
I understand that's how it was left. I'm not saying it's okay. I'm trying to explain to you how this court can resolve this case. And in my view, in the Commonwealth's view, even if we both ask for a mistrial and you get to the manifest necessity, here it could not be continued, not only due to the juror issue, but due to the experts issue. And at trial counsel represented that the expert was booked for months out. So this wasn't going to be a case where you hold over a district court jury for who knows how long. That's not really something we do.
All right, so if that's the way you want to play this, didn't the Commonwealth goad defense counsel into asking for a mistrial? You're holding the trial at bay. You're holding it hostage. You're saying our witness wants to come in, but she can't come in for this day, so we're going to go tomorrow. But I know that the defense is not available, so you have to declare a mistrial.
I don't believe that's how that happened, Your Honor. If you look at it, the Commonwealth came in stating she's not coming in and realized that it may result in a mistrial. At that point, he asks for a mistrial. Then the victim calls back and says, you know what, okay, noticing that this is going to be, end the case, I will come in. I can't get there today. I'm in school. I have transportation issues.
You call it manifest necessity. Why couldn't the judge have said, okay, Commonwealth, next witness?
Because the next witness actually lined up was the victim's mother, who was also having the same issues.
Okay, so she's not there. Next witness, Commonwealth.
She could have done that. She
Okay,
could have done that.
and you would have said, we have no more witnesses?
Yep.
And he would have said, depending on how this went, he might have said,
Directed verdict.
let's strike, we obviously have to strike this testimony, cross-examination isn't complete, and the judge would have said, I guess that's right, and then he would have said, required finding.
Absolutely. That is one option.
So there is not a manifest necessity for the mistrial because there was another avenue that the judge could have.
But that manifest necessity doesn't mean that you have to take that version. Manifest necessity if there is a finding that we cannot continue due to something, which there was that finding. It doesn't have to be, it's within the judge's discretion. And if she determines that because the victim can't come back today, but the victim does want to continue, something has gone on that the Commonwealth can retry.
I've seen an awful lot of cases where a defense witness doesn't show up. I don't think I've ever seen a prosecution one, although I have seen the prosecution say not ready for trial millions of times because their witness isn't there and the judge always says, okay, we'll hold it off. But I've seen in the middle of trial, defense witnesses not showing up. Maybe you have as well. I don't ever recall a mistrial being declared. They just, you don't have a witness? Okay, you lose, or you don't get the benefit.
The defendant doesn't have a burden of proof at that point, so I think the difference is great. The Commonwealth has the burden of proof, and so if the witness doesn't show up, it's in a different light. The witness is the evidence for the Commonwealth to suffice
The alibi
their burden
witness
of proof.
doesn't show up. And so all the jury has heard is you say X, but this highly credible witness, the local priest, is going to come in and say, no, we were on a retreat that night. right? But that person doesn't show up. I mean, it depends what the witness is, right?
I think it also depends on what the judge finds factually. This is a fact-determinative outcome. And I believe that if the local priest didn't come in for the defendant, I'm sure that my brother would stand up and say, I'd like a continuance, or I'd like to move this witness to the next day and try to get in touch with him tonight.
But
Or the defense can also ask-
you'd oppose that.
Possibly, I don't know.
Yeah.
The defense can also ask for a capias, and that was not done here due to the nature of the victim.
And the Commonwealth can too.
And that was not done here due to the nature and the age of
Why?
the victim. Because she was a teenager, she was a child.
Can't a capias issue to a minor?
I'm sure it can, however, she didn't feel that that was the right way to go about this.
So the judge made a factual finding on record, page 439. Both parties indicated that they were requesting a mistrial. You just said this, so she made that finding. There was
Correct.
no objection. So both parties requested a mistrial.
Sure.
You don't request a capias. So I go back to, isn't the Commonwealth holding the defendant hostage here by saying, now we want a continuance, but we know you're not available, so I guess it's going to have to be a mistrial?
The Commonwealth can put out there what they want to as far as how they believe the case should end. If the judge buys it, the judge buys it. If the judge determines she needs more information, she asks for more information. Here it was clear, based on the exchange during the actual hearing and based on her findings on record page 24, that she didn't find there was any prosecutorial misconduct. She found that this was, in fact, going to be on for another trial that was in her considerable discretion, and where there's no clear error, this court does defer to that discretion.
What if we find it's an abuse of discretion that she said that there wasn't prosecutorial misconduct?
Then you would be finding facts.
Well, no.
Yes.
Both parties request a mistrial. You say you have a witness that's not coming in. You don't want a capias. That's factual findings that are in the record.
Correct.
And why can't we find that based on that, it's prosecutorial misconduct at that point to not say, move for a mistrial?
Then that would be, I guess, within Your Honor's purview, or perhaps it might be within Your Honor replacing your discretion for that of the trial judge. The trial judge sat there through this entire thing, took multiple breaks to consider, had the filings before her before she rendered her written judgment on Record Appendix 24 on the Commonwealth's motion. So this isn't a case where the judge just said, okay, this. She did take all of this into account. It was a tough decision. I'm not here saying that this wasn't confusing or wasn't, I guess, out of the ordinary, as my brother would put it. But this is what happened. In a plain sense reading, she found that a mistrial should occur. She found that a retrial could occur, and she found that there was no prosecutorial misconduct. And I saw that, Judge Smith, you had a question.
I do have a question. My question is to you, fortunately, there's no reference to manifest necessity. There's not really any discussion of prosecutorial misconduct when the judge ruled for mistrial, decided to mistried the case. In her reconsideration, she refers to Curtis and Cobb, and she makes it pretty clear that she found there's no prosecutorial misconduct. Are we to infer to that her decision on the mistrial was that essentially the defendant assented to the mistrial and that there was no prosecutorial misconduct?
I believe so. I also would say that even if she were stating that it was a mistrial with prejudice was in fact an objection of sorts, I would still state that looking at the record, looking at her decision, she went through the processes necessary to overrule that objection soundly.
So you're saying that you believe on the record she found there was a manifest necessity to continue for a further trial?
I believe that during the hearing, knowing what was going on, seeing the different ways that could continue, I believe that it can be found. I'm not saying that she necessarily enumerated that, I guess, verbal or specifically, but I do believe it can be found in her decision, especially where when you have a defendant's objection, you then move on to the need to retry and the prosecutorial misconduct. Where she found no prosecutorial misconduct, I think goes hand in hand with that. And in fact, when the appeals court looks at whether or not this has happened, it not only does there are two prongs. Counsel's full ability to be heard, which I think is clear he was, especially given the fact that he filed an opposition that was lengthy also. It's not a standstill moment.
Right, and the judge has to carefully consider.
Correct. And number two, whether the trial judge gave consideration to alternatives. And here, she knew she couldn't go on, they couldn't go on Friday. The expert was booked out.
How do we conclude that she couldn't go on Friday?
There is, and I apologize, I was looking for it while I was sitting here with the transcripts. There was a juror that could not continue on Friday. The expert, I believe, my brother states that the expert had surgeries lined up the next day. I know he had one that afternoon. But there was clear discussion at some point.
That's what makes it difficult on this record to determine whether there's manifest necessity. I can't determine whether the expert was available that next day or not available on that Thursday.
Well, I think given what the defendant filed, especially in light of the prosecution's motion to retry about the expert schedule, it was jam-packed. It was booked out 4 or 5 months in advance. And this trial had already been continued once due to the expert schedule, so that was clearly, I think, a part of the judge's, the judge can consider that.
Weren't there 2 alternate jurors?
I believe 8 were impaneled.
So that you could dismiss one if they had to be dismissed for Friday and still go forward?
That is true, Your Honor, but I would point out that at no point does this defendant ask for this specific jury. That is also something that can be considered. At no point did my brother ask to retain this jury in any fashion.
Where do I look? What case says that can be considered?
I don't have that right off the transcript site right off the top of my head, but I know I can happy to submit a 16L on that, but I know that there is no, where there's no request for the specific jury, it may actually be in my brief, but I'm blanking at this moment. If I may finish my thought, that is something that is also considered. At no point did he ask for to retain this jury, and that is along the mistrial line of cases. So if the court has no further questions.
No, I would just say I appreciate 88 Page being present.
I have a question.
Okay.
You're asking us to find a manifest necessity potentially because a defense witness is not going to be there. Number one, the defendant's lawyer never says that. Number two, the defendant may not call that witness. It's under no obligation to call that witness. So how can the judge make a finding of manifest necessity about a defense witness when defense counsel doesn't even ask for it?
Well, the defense counsel did state that he could not be there that afternoon and did not want to take him out of order. So I think that is something else to consider. I would also state that in the way that she's analyzing this, if the victim and her mother are to testify the next day, it would inevitably either be into the afternoon or the next week. We also had the juror issues. And so it's not just that the expert was unavailable at that moment, but she knew of the expert's busy schedule. The defense counsel had stated that multiple times throughout, and she knew from the previous trials, or the previous trying to be trials, that this expert had these scheduling conflicts. So I don't think it's out of the range of reasonable knowledge there.
How do you, I know you're out of time, but I have a question. How do you understand a request for a mistrial with prejudice? What do you understand? If that had been allowed, what is that? Like, what is the judge, as a practical matter, what would that look like?
Sure. So I think a mistrial with prejudice is exactly what my brother was trying to explain, is he was asking for a dismissal. As this court knows, a dismissal during trial is not a thing. That would be being set at bar. So I think here, mistrial with prejudice is really asking for the court to go into that analysis of whether or not this court could put the case over for another date due to either the manifest necessity and the prosecutorial misconduct. My brother was extremely clear, both in his oral argument and in his filing subsequent, that prosecutorial misconduct was his claim here.
Okay, thank you very much. Excellent argument. Extremely unusual facts. So thank you very much. You've both been very helpful to us. The next matter we will hear is an impounded case. It is number 24447, Department of Children and Families versus Guardian. I remind the parties to use, well, you could use pseudonyms, but I think it would be easiest to just use titles for people, mother, father, guardian, and so on. I gather that the appellees will be dividing their time 7.5 minutes and 7.5 minutes. Okay. We will hear first from Attorney Paquin.
Members of the panel, may it please the court. Nicole Paquin on behalf of the guardian grandmother and her, who is present along with her partner here today. The guardian asks that this panel vacate the order finding her unfit to parent child and to remand to the juvenile court. The first item I'd like to address is the standard that applies here today. The department argues for the first time on appeal that the standard applicable to a guardian who has been raising a child is different than that of the standard that applies to a parent. The department argues suitability instead of unfitness. For the argument today, I don't believe that the actual standard really affects the argument because guardians' allegations of error apply equally to either standard. It would be helpful if the court could clarify the standard, perhaps publish a decision on that issue. But for the purpose of argument today, the trial judge made significant factual errors that undermine either decision or would apply equally to unsuitability or unfitness. First of all, the judge's most critical findings are contrary to the evidence. There are a few findings that form the basis of the most critical parts of the judge's conclusions of law, including that a drug, fentanyl, was an easy reach and easy access at the time that the child was removed from the home. This is contrary to the evidence. There's no evidence to support that. Instead,
We don't know what fentanyl residue is, I don't think. I know I don't know, at least, what fentanyl residue is, and I don't know if that's something that's that could, that contains the drug fentanyl, or it's something else.
we do know that the detective testified that there were no drugs in the home. That
He also testified that there was a spoon with fentanyl residue in it.
he did testify that there was paraphernalia included in the mother's
Including a spoon
purse.
with fentanyl residue, right?
There was a baggie with fentanyl residue. I don't recall there being, I recall there was
thought
a spoon.
The residue wasn't on the spoon, so it was what's left over in a bag.
That is my
I
understanding
see.
of the facts.
So it's actual fentanyl.
We don't know. All we know is that the detective testified that in his experience, he identified this as drug paraphernalia that was included in mother's purse. He testified that there were no drugs in the home. He also testified that if he thought there were drugs in the home, he would have applied for a warrant to search. He did not think so, and so he did not do that. He also did not seize the paraphernalia. He asked the guardian to dispose of it, and her sister did do that at that time. But that is different than the judge's finding saying that fentanyl was an easy reach and easy access. The judge also found that the detective opined that the mother was using drugs in the home. And again, the detective did not testify that. The detective instead testified that he had no knowledge that there were drugs being used in the home. And that's at transcripts page 40 to 41. So we have a detective who was there at the scene when the mother was arrested, which ultimately led to the child's removal, who very clearly testified that there was paraphernalia but not drugs, that paraphernalia was different than drugs, and that he had no use of actual drug use in the home. And yet the judge found that there was fentanyl and easy reach and easy access, and that the detective had testified that mother was using drugs in the home. She also found that the guardian had failed to facilitate an IEP or prioritize child's educational needs, which is contrary to the evidence. The department admitted that it had no educational concerns for this child, and that's at Record Appendix 26. The guardian is the individual who, back in kindergarten, had obtained the child's individualized education plan, the IEP. That's at Record Appendix 236 and transcript 66. There was also no action plan task regarding education, and that's clear at Record Appendix 289, 8 and 9. So we have multiple findings where the judge is very critical of the guardian, and these are not supported at all by the evidence. The judge also made significant leaps, real speculation instead of reasonable inferences, finding that in findings of fact 30 and 45, that the mother had been residing or living at guardian's home based only on the fact that the guardian had sought legal intervention to protect the child against the mother. So in November 2014, the guardian obtained a restraining order, and that was issued against the mother at guardian's home. In 2021, the mother was picked up to be sectioned at guardian's home.
Was that made permanent, that order? Did it expire?
It was in effect for a year, and then it expired.
So after 2015, there was nothing, there was no law preventing the mother from coming to the guardian's home?
Correct.
Okay.
In addition to these findings that are not supported by the evidence, the judge made no findings of any of the positive evidence that weighed in guardian's favor. There was evidence that this guardian, this grandmother, stepped up to raise her grandchild. She successfully parented this child for nearly 10 years, and there are zero findings regarding all of the good parenting that occurred during those nearly 10 years. This guardian and her partner provided stable housing, a clean home, a loving environment. The child was up to date medically at the time of removal. Again, she obtained the IEP for the child. The department repeatedly found in its own records that the guardian was doing what it needed to do insofar as supporting the child.
Let's interrupt you.
Sure.
We may hear from the department that she may have been up to date medically, but she wasn't dentally. You respond to that, or your response to that?
So I'd like to remind the court that the child here was last seen by a dentist in 2020, and so 2 of the years when the child was not seen by a dentist was during the height of COVID, when many people were not seen by a dentist. The guardian was clearly committed to the child's well-being and would have gotten the child caught up dentally. She was up to date medically, which I think shows that she was taking care of this child. And furthermore, being dentally delayed would not warrant on its own removal.
Well, it's not a question of on its own. You're not saying that it's safe to have the mother in this house with the child, are you?
I'm saying that it's unfair to remove the child from the guardian based on her allowing the mother into the home. It's not fair for the guardian to be held responsible for knowing what mother has in her purse. There's no evidence whatsoever that the guardian knew.
When did she say she used the same drug dealer as the mother, Hector?
There is evidence of...
When?
I'm sorry, what was that?
When? Is that contemporaneous with all this?
That was included in the 51A.
The 51A from that day?
Yes.
Okay, so she uses a drug dealer that's the mother's drug dealer. The mother has been in the home at least sometimes that the guardian hasn't been truthful about. There's someone outside the home trying to buy drugs. Well, it's her home. I guess I don't know from whom, but it seems possible that it would be the guardian. The guardian is later involved in a drug deal in a supermarket parking lot. So I'm not sure how any of that suggests safety. right? It's a safety concern that we're talking about, I think.
So in regards to the individual who was outside of the home, grandmother, the guardian, was not home at the time that that
Yeah,
person...
but no one knew that was going to happen. At least according to the grandmother, right? It was a spur of the moment thing, leaving her with the mother. The mother's not a babysitter.
Mother is not a babysitter. The guardian made the decision to leave a 10-and-a-half-year-old child alone for...
Not alone.
in the same home as her mother, but not with mother as a caretaker. And guardian did not go far. When the police called her, she was back home in 10 minutes. So she did leave child with...
Was the drug purchaser still there?
When she returned home?
Yeah.
I do not believe the record is clear on that, but I don't believe the record's clear on that. But there's no evidence to suggest that individual who was outside of the home was there for the guardian as opposed to the mother. The mother is the one who had paraphernalia in her purse. And guardian's substance use, which she had admitted to, has never been known to interfere with her ability to parent child.
You don't think maybe getting arrested might lead to incarceration?
The law is clear that substance use alone is not sufficient to render a parent
Catherine, there was
unfit.
no neglect of the child, right? It says in the absence of neglect, we can't take this into account. Now, I'm not sure how far that goes. I actually think that's a difficult question, right? Because we don't want to obviously say people with drug problems are inherently unable to parent their children. That seems both obvious and reasonable. But there was neglect here, and there was substance abuse here.
The only, if you want to call it that, the only neglect, the only...
I'm ready to call that day neglect, yeah.
That day or the dental care?
I'll take both, but I know you complain about the dental one. I'm not sure I quite see it your way, but I see what you're saying.
So
but
if
let's take the leaving her with a drug addict on the verge of death who has paraphernalia and drugs in the house, gets her to lie to the police who come storming in to arrest her. Let's say that's not a safe environment for a child.
If we assume for the sake of argument that that was not a safe environment for the child, I would say that that one day does not negate 10 years of good parenting. The evidence is clear that the mother has not been back to the home since that day. The guardian is capable and willing to enforce boundaries, and that one...
She had a chance to get a no trespass order. She got one against, I believe, maybe the mother's boyfriend. And I believe she indicated she did get one against the mother, but she actually didn't. Is that fair to say?
That is fair to say, and mother instead was sectioned again the next day after mother was arrested. I would argue that the guardian knew that it wasn't necessary to get a no trespass order because mother was not coming back. And she had made that abundantly clear that mother's not welcome in the home, mother has not been back in the home, and that one day, that one unfortunate day where this imperfect guardian may have made a mistake does not negate over nearly 10 years of good parenting. She raised this child, she stepped up, she's not a perfect person, but she had this girl doing as best as she could in school with her IEP. She was in a loving environment, in a stable home with two very stable, loving caregivers. She was well cared for, she had pets and interests. She was engaged in cheerleading.
She wasn't engaged in cheerleading. There was a finding of fact about that.
There was a finding in fact that is not supported by the evidence because the department itself admitted that the child was engaged in cheerleading when she was in the guardian's care.
I thought we had from the school or somebody that she had no, or maybe her own statement, that she did no activities, but she hoped to do cheerleading.
There was
But whatever, this case isn't about whether she's a cheerleader or not.
Correct, it's not about the cheerleading. But this was a loving, successful home, and then there was a terrible event. And whether that event, and the decisions that led up to the mother being arrested and the child being removed warrants a finding as unfitness, I think the answer is no. The guardian was not unfit. this was not a basis for removal. It's not a basis to continue to
It
have.
was certainly a basis for removal.
Perhaps at the moment,
Yeah.
I misspoke.
Would
But
you
it-
agree that if the findings are enough for us to conclude that grandmother would allow mom in the home and with this child in the future, that that's enough? Because I'm straining to not find that, to conclude that, based on just the issue in November of 2022 when she says she allows mom and the boyfriend in because she didn't think she was using needles, because she didn't find fresh track marks, but then the police find fresh track marks. So it sounds like she's allowing mom in the home.
prior to the incident, yes, she allowed mom in the home. I think her testimony was between 4 to 6 times a year. I think the
Yeah,
testimony.
but that doesn't make that true.
I think the judge's credibility determinations have to be viewed in line with the uneven weighing of evidence. This is a judge who seemed to have her thumb on the scale where she ignored 10 years of good parenting, 10 years of evidence, made no findings, if I may just finish this thought, made no findings of any of those positive facts in order to actually weigh them against the negative. The judge did not engage in that exercise. And so the basis of her decision is quite unclear, whether she even looked at that positive evidence, which she was required to do so. I see my time.
So you may concede there's some lapses in judgment, perhaps, by the grandmother and your client, and further that you may concede there's some smoke about substance abuse. You know, there's reference to cocaine use, there's reference to Suboxone, there's reference to, no, I didn't take Klonopin, it's, you know, the reference I'm speaking to. And it's a difficult position, perhaps, for the department to be in, to give her a chance to show, no, there's no substance abuse that's affecting my judgment. You can show your sobriety by showing us the negative results. And she doesn't. What is the department, what are we to infer from that?
Well, the department had the opportunity to file a motion to obtain her records. They attempted to do that, but their motion was denied because they were unable to articulate sufficient basis to obtain those records. And I think that really highlights the issue here. The department had some amorphous...
That was not just for test results or prescription information, right? That was for her whole mental health,
Mental health and
what she had
treatment.
said to her therapist. Okay.
Correct. And they never attempted to narrow that. They never sought and order compelling drug tests. They had avenues to obtain other information, and the department did not do so. And then at trial, the department's own social worker testified that they wanted this information so that they could determine what the concerns might be, because they weren't sure what was happening with this grandmother, because there was no evidence, and the department concedes this, there was no evidence that guardian ever used drugs while in the presence of the child. The child informed the department that she had never seen guardian use any drugs. There was never any indication that guardian used any substances while in a caretaking capacity. And
When was the marijuana concern?
The marijuana concern was in 2004.
Okay. Yeah, I thought it was a long time
And the
ago.
judge also reaches back to 1996 for another negative finding, which again, I think goes to a curious decision to reach nearly 30 years back to marshal negative facts against the guardian while ignoring 10 years of positive parenting. I know I'm out of time.
Okay, no, there are no further questions. Thank you
you.
very much. We will hear next from, I think, Attorney Fiminari.
Good morning, Your Honors, and may it please the Court. Assistant Attorney General Christine Vimineri on behalf of the Appellee Department of Children and Families. The Court should affirm the judgment and decree of the court below, which found that the subject child is in need of care and protection and should be committed permanently to the custody of the Department. The Court should affirm because the lower court did not commit an error of law or an abuse of discretion in finding that the child was in need of care and protection. At the outset, Your Honor, I want to make clear that regardless of which standard the court applies here, the department's position is that the judge's opinion below meets that standard.
Did you argue for, whatever test you're looking for, the
Suitability?
Suitability, yeah. Did you argue for suitability below?
No, Your Honor, below,
So why isn't that waived?
it's not waived, Your Honor, because it's just a legal analysis, and there's case law such as Hawthorne Inc. versus Warrenton Realty and Commonwealth versus Ville, which holds that the appeals court can affirm on any grounds supported by the record, including if the legal analysis differs from that of the judge
That
below.
hasn't been raised below? I've always thought it had to be raised below.
I don't believe so, Your Honor. My understanding from the Hawthorne versus Warrenton Realty case is that if the legal analysis can differ and you can adopt different reasoning to affirm the judgment, even if it's not specifically relied upon by the judge. But in any event, Your Honor,
Did you cite that in your brief, that case?
I don't believe so, Your Honor. I can provide the site. It's 414 Mass 200, 1993.
Thank you.
Well, I'd like to go to an issue that was discussed by opposing counsel. How was the substance abuse of the guardian connected to the child's welfare in this case by the judge?
Yes, Your Honor, and before getting into the facts, I just want to emphasize that this is not a case where the guardian's substance abuse was the sole reason for the unfitness finding. This is a case where there were multiple factors, including...
There's an awful lot in the opinion about substance abuse and refusal to sign releases, so it seems to play a substantial part in the judge's analysis, although obviously we'll have to figure that out.
Yes, Your Honor, it was definitely part of the judge's analysis. Also part of the judge's analysis was that the guardian in this case was repeatedly unable to keep the child safe from interactions with the mother. And so the court below, it was within the court below's discretion to consider the allegations of grandmother's substance abuse in considering how that affects her poor judgment.
Wait, so what's your answer to Justice D'Angelo's question? How is it connected, you say?
It's connected, Your Honor, because it relates to the grandmother's judgment, and it relates to the circumstances the child was exposed to.
There's no finding and no connection that I could see based on the facts that at any time when mom came home, that grandmother was high, under the influence, even utilizing drugs at all. So how do we make that connection that it goes to her judgment of allowing mom back at the home, as opposed to, and I'm not saying this was necessarily a good thing, she wanted her daughter to see her baby, which again, might not be a good judgment, but how do we make that differential based on substance abuse?
Yes, Your Honor. We acknowledge that there is no a circumstance in the record where the grandmother was found to be under the influence while supervising the child. However, adoption of Luke says that evidence of alcohol or drug use is relevant to, but not dispositive of a parent's willingness, competence, and availability to provide care. So here, it was not an abuse of discretion for the court below to consider this as one factor. Additionally, Your Honor, Appellant's counsel relies on the case of adoption of Catherine to argue that there has to be this type of nexus. But adoption of Catherine involved a case where it was the only aspect of unfitness that was available. Specifically in that case, the social worker testified there were no other concerns around child's care. Here, there were significant concerns around child's care, and specifically on child exposure to mother's substance abuse.
But there still has to be a nexus between the guardian's substance abuse and that decision. And I guess I mean, you know, and I'm not sure, you know, can a judge just take judicial notice of the fact that when people are stoned, they're not particularly good caregivers, or you know what I mean? I'm just not sure I understand where the line is or how we're supposed to know. I mean, you know, if someone is taking illicit Suboxone, you may not, well, although that's supposed to not, I don't know enough about its effects to really know, but whatever, cocaine, yeah, we can figure they're probably not a very good caregiver while that's going on. But Catherine seems to foreclose some of that. inference?
No, Your Honor. I would direct Your Honor's attention to the unpublished decisions of adoption of Callie and adoption of June, which are cited in our brief. And the court there found that it did not have to be an exact instance. Instantly there's a problem with the child. It can be considered if there are other circumstances of neglect. But in any event, Your Honor, we submit that even, putting aside the substance abuse issues, there was significant safety concerns for this child. In addition to the November 8th, 2022 incident that led to the child's removal, if we look back, in November 2021, grandmother was charged with possession of a Class B substance for possession of unprescribed Adderall. In late 2020,
How did that place the minor in danger?
It shows, Your Honor, the pattern of the caretakers for the child being involved in substance abuse. But more to the point, Your Honor, the guardian testified that between January 2015, when they became the guardian, and November 2022, when the child was removed, there were at least 6 occasions on which the guardian had allowed the mother to visit child in the home, but mother ended up appearing not sober during the visit, and guardian had to ask mother to leave. So
Why is that inappropriate?
it's inappropriate, Your Honor, because the child was exposed to mother's substance abuse, and the 51B report and the court investigator's report indicate that the child described seeing the mother under the influence.
And the guardian, when she sees this, tells mom to leave. Isn't that the actions you want a guardian caretaker to have? You allow mom into the house because it's still mom, and as soon as, I don't want to say as soon as, but when guardian or caretaker sees that there's an issue, tells the mom, leave. It would be one thing if she allowed her to stay. That seems inappropriate. But she sees something wrong and she says, leave.
And she's got a restraining order as well.
Your Honor, I see my time has expired. May
You can
I
keep
answer your
answering
question?
questions.
Your Honor, so these were repeated incidents where she asks them to leave, but then grandmother in October to November of 2022 allowed mother and mother's boyfriend to stay in the home. And child's report to the 51B investigator showed that child was again exposed to substance abuse, and that the police report, as well as the police officer's testimony, indicated that there was evidence of intravenous drug use in the home near the child. With regard to...
Wait, including needles or just a spoon?
Yes, Your Honor. Let me just find the exact...
No, it's okay, you don't have any time. So, but if there are needles, we can find it.
Yes, Your Honor. It was syringes, corner-cut baggies, a spoon, and remnants of intravenous drug use is what the officer testified to. Your Honor, I know I'm over time. May I briefly respond to Justice Smith's question? Regarding the restraining order, Your Honor, a restraining order has not been taken out against mother since 2015. Originally, guardian reported that she had taken out a restraining order against mother again, but at trial she admitted that that was only against mother's boyfriend.
Is there any evidence that she knew about the firearm possessed by the boyfriend?
No, Your Honor, there's no evidence of that. She maintains that she was unaware of it.
Well, she can maintain that, but there's no evidence. There's no evidence to the contrary.
No, Your Honor, there's no evidence.
Does the judge include the risk of having someone with a firearm in the home? I thought it did.
Yes, it does, Your Honor, because a guardian needs to evaluate people who are coming into the home.
At-risk them?
No, Your Honor.
Well, how would she find out that the person had a firearm?
I think it's reasonable, Your Honor, especially where there was this past history of mother's involvement with criminal history and mother's boyfriend's involvement with criminal activity.
Which violent criminal activity involving guns?
The mother had been involved in criminal activity that, I forget the exact things, Your Honor, but I believe it included things like assault.
With a firearm?
I don't believe so, Your Honor.
Okay.
From 2016 to 2022, did the department, in either an action plan or anything, put grandma or the guardian on notice to not let mom go near the child?
I don't believe so, Your Honor.
Shouldn't they have? If they find it, if the argument at trial is it was inappropriate for mom to be near this child, and grandma is the caretaker, shouldn't DCF say to grandma, don't allow her near the kid?
I believe, Your Honor, that the action plan involves keeping the child in safe situations, so I don't know that the department was required to be more specific than that.
Okay.
Thank you, Your Honors,
Thank
unless you have
you
any
very
further
much.
questions.
And we will hear finally from Attorney Kruger.
Good morning, Your Honors. Yvette Kruger here. May it please the Court, Yvette Kruger here to represent the appellee child in this matter. The judge properly concluded that grandmother cannot and will not place the needs of the child before hers and provide the child with a safe and stable home. Grandmother's unfitness is abundantly supported in at least 3 important ways. First, grandmother's long-standing and ongoing substance abuse issues and associated criminal activity began in 1996 and culminated in a horrific traumatic event involving the child. Your Honors have all discussed the details of that event, so I won't go through them again.
How did her substance abuse, the grandmother's substance abuse, have anything to do with that event?
This goes to your question of the nexus.
Mm-hmm.
The judge specifically addressed that in conclusion 13 and said she specifically considered adoption of Catherine, but that in this instance, that the circumstances, her history is relevant, the circumstances of the event is relevant, her refusal to acknowledge the circumstances of the event,
But what does that have to do with her substance abuse? Where's the evidence that the reason she's denying this is her own substance abuse, or that the reason she has such poor judgment is because of substance abuse?
The poor judgment results in this orbit of substance abuse around and substance users and
Well, I
related
agree.
criminal
Bringing
activity
in
around
an
them.
intravenous drug user with needles maybe is bad, but
Correct.
that's not grandmother's substance abuse. That's grandmother's judgment.
Well, grandmother uses the same drug dealer as mother. I think that's a strong association, Your Honor. In 2010, she's using marijuana, and her boyfriend is supported for selling marijuana out of the house, people frequenting the house.
To 2010.
That's 2010.
When was the child born?
I'm just saying, this was with mother in the house. The pattern has been repeated where there is this, let's call it a toleration of these behaviors, substance users, substance abuse, whether grandmother is in the corner stoned out of her mind or not, these people...
There's no evidence of that, right?
No, there is not. However, Your Honors are asking, did DCF say, did the department say, mother should never be in the home? As a mother, and I see someone who is on the verge of death and is asleep, sitting up and standing up, it is my parental obligation to not expose my young child to such a person, DCF orders or not. This is common sense. This is an ability to safely protect and provide a stable home for a child.
Is the child still in, well, first of all, please don't tell me any attorney-client privileged information. When did you most recently face-to-face speak with the child?
3 days ago, Your Honor.
And is the child still in the placement that they were in at the time of briefing?
Yes, Your Honor.
That placement was determined by the grandmother's recommendation. It's one of her neighbors.
Correct.
And the child is apparently being allowed to visit her grandmother a bunch? There's something about this that...
The record states that she had weekly visitation.
Oh, and then until at some point it became supervised, is that right?
Yes, correct.
And is it still supervised?
Yes.
Okay.
I would like to address Guardian's argument that Detective Dees stated that he did not know that mother was using in the home. His testimony is clear, and I go through it in detail in my brief, that he stated he agreed he could not have said that she was using on that particular day, but that based on his many years of being on task forces and hundreds of thousands of federal and state, that he knew she was using based on his prior knowledge of mother, based on her appearance, and based on the paraphernalia. This was a finding. The judge credited in finding 50 all of Detective D's statements, testimony, and opinions. The second thing I wanted to address was, I think that's it.
Can I ask you this? DCF has complex set of rules about when substituted judgment for a child is supposed to be used versus the child's actual own position. I don't know what age where this child falls on that spectrum. Is the child's position your substituted judgment, or is it the position of the child?
This is very
Themselves.
clearly the position of the child, which supports the child wishes to remain in her foster home. She changed her position at the age of 12, 8 months after trial, and after being in the foster home for 2 years. Her change of position supports the fact that she wishes to be in a safe, stable home. And I think that's powerful support for the judges for an affirmation of the trial court's, lower court's decision today. I would just like to add that grandmother's continued inability to protect the child and have an appreciation for the need for the child's safety and security is supported by her testimony that her only mistake was not knowing that a warrant was going to be served that day. She never expressed any remorse for the for the harm that was done to the child. She blamed instead the department. She claimed the police reports were false, that the reports were inflated, that there was no basis for maintaining boundaries because the child never witnessed the mother under, I see my time is up, if Your Honor have any questions.
Your time is up, although, thank you very, very much. These are the most difficult cases we see, so thank you to all of you for your very helpful arguments. You want to take a break or no? Take a break? Keep up to you. I don't got one more. Let's do it. Oh, the case is submitted, I should say, for the record. Although sometimes I don't. Okay, we have next two paired cases. They are numbers 2457 and 2458. The first is Grassi versus Dean Bank, and the second is Spencer versus Dean Bank. These involve the same exact issues, unless you correct me and I've missed something. They seem identical to me. So although each side is formally entitled to 30 minutes because it's two cases, I'm going to propose that we do an ordinary 15-minute per side argument, and if you need extra time, then we'll be relatively generous with it. Is that?
It does, Your Honor. I think the cases are identical.
Okay.
The briefs are identical.
All right, very good. So, having said that, we will hear from Attorney Wozniak.
Thank Thank you. If it pleases the court, Attorney Wozniak on behalf of the appellants. Your Honor, this is a case involving a lending issue as between the bank and my clients. In this particular instance, my client owned an existing restaurant establishment in Franklin, Mass., King Street Cafe. He was branching out to open and had opened a second location in Millis. That second location, initial purchase was funded by the bank in this particular instance and in the amount of $80,000. At a certain point in time, due to the growth of the business, my client then wanted to branch out, expand the business, renovate the facility, and therefore increase his revenue. He had an existing long-term relationship with this particular bank and had, in the course of that relationship, made it clear to the bank what his plans, what his desires, and what he intended to do in going forward. He met with the loan officer as indicated in my brief and on extensive occasions and as supported by his affidavit. It's our position that in rendering summary judgment on behalf of the bank, the court erred by failing to take into account, first of all, the facts asserted in my client's affidavit and the facts in responses to the request or undisputed statement of facts that were in the record.
Counsel, do you agree that your client received a commitment letter no later than June 1st of 2018?
Yes, Your Honor, I deny that, yes.
You deny that?
Yes, and if you read his affidavit, it supports that contention and that conclusion.
What difference does that make? It was signed on the day of the closing.
Well, the difference it makes is this, Your Honor, because we also have a claim of fraudulent inducement in this particular instance. And you have to understand the circumstances surrounding it. Because what had occurred and transpired prior to that closing date was my client was continually, and this is supported not only by his affidavit, but also in a very chronological, very detailed fashion, Exhibit B to his affidavit spells out the efforts that he had made and what his understanding was in going forward with respect to this note. He went forward because he understood from the representative of the bank that he was going to receive financing. In their words, it was a no-brainer. So he began commencement of the renovation, closed his business. And understand, Your Honor, it wasn't without consequence because at that time he was also paying a loan to the bank on an ice cream machine as part of that business plan that he was going to implement. The bank loan officer came there multiple times, continuing to insist that lending was coming, funding was coming. My client, based upon those representations, went ahead, expended his own funds. At a certain point in time, the pot ran dry. He had no further funding. He had no ability to do it. He was losing subcontractors. He was losing the season, and he was desperate to get the business going and the money's coming back into the facility. He had, as I said, expended all his capital reserves. At that point in time, they scheduled the closing. That was June 6th. Now, the court, in its determination, looked at a couple of things. First of all, it reached the conclusion that my client's affidavit was self-serving based upon the fact that because of the commitment letters and the dates of the commitment letters, the court assumed, contrary to my client's statement in his affidavit and the letter that was attached as Exhibit B, that my client knew about the letters and had an opportunity to walk or back out of the transaction. He walked into that transaction with the understanding that it was going to be an equity line. He had adequate security. He had adequate collateral.
Slow down, counsel. So are you saying that the affidavit where your client says he didn't get the commitment letter earlier than June 1st, that's a material fact that's in dispute?
Exactly, Your Honor. And it becomes even...
Tell us what's material about it, because then you mentioned to Justice Rubin about fraudulent. Tie those in.
Well, the fraudulent inducement claim is based upon the reasons why he went to go sign the note in the first place. And the issues and the circumstances surrounding that lend one to believe that my client at that point in time, based upon the representations of the bank, based on the closing of his business, based upon the expenditure of his capital reserves, was suffering from, at least at that point in time, financial or economic duress. He had no other choice. And I note for the court a more interesting part. The bank is rested at the summary judgment hearing on the fact that, well, we had a commitment letter. Well, there's two commitment letters. There's one dated June 1st and there's one dated June 6th. And they're saying, well, the borrower, my client, never reached out, never got the inspections completed. Well, that, as you see in my brief, that's betrayed by the record, because a couple of things occurred. First of all, we have two commitment letters. One, where it's the provision concerning construction, is said NA, and next to it is the abbreviation for the name. We infer, because we can do that, and as the opposing party to a motion for summary judgment, and the facts that lead to, in a light most favorable to my client, that that is the closing attorney for the bank. Then why do we need a second commitment letter? Again, letters dated in May 22nd, but not provided to my client at the earliest, if you believe the bank, till June 1st, and then subsequently June 6th to have re-signed? My client is evidence of a couple of different things. First of all, when the loan was taken, my client had tendered to the bank receipts in approximately of $137,000. And I'm taking some of this from memory, so I'd ask your indulgence if I'm not exactly precise. But at that point in time, the $200,000 loan also repaid the first position, or the mortgage that the bank had previously had on the property. So that was $80,000 approximately. He got a check, and there was remaining in the balance of that account $78,000, which they did not release. Now the bank says, well, he had to request an inspection in order to get the draw. Well,
wait, explain to me again what the note, of course, doesn't say we're going to withhold $78,000.
That's correct, Your Honor.
So where does that number? I don't understand. It was an amount in an account? I don't,
Your Honor, if I had the answer to that, it would be in my brief. I don't have the answer to that. That's why I'm here. I'm here because the bank, in its wisdom, went ahead and indiscriminately determined that we're going to give you this. Now, they claim that was after the first inspection. No, it wasn't, Judge. It was at the closing they gave him a check. They had the $78,000 wrapped up, and they contended, well, you didn't get the inspections. However, if you look at...
Wait.
Yep.
So on the day of the closing of the loan, everyone signs the 4,000 documents that nobody looks at as they turn the pages. And then you get a check. Maybe it's wired. I don't know how you did it in this case. The amount of that check is not $200,000. It's 120 something. Is that what?
No, Judge, it's not. It's the balance of the loan without the, so it's approximately $138,000 left after they pay off the existing loan on the property to the bank, because the bank had a mortgage already. From that $138,000 approximate dollars, they took and gave to my client everything except for $78,000 of that amount.
So they gave $60,000.
Somewhere in that range, yes. 63, I think it was. Somewhere in that range.
And so you or someone is sitting, well, maybe there's no lawyer at the closing. Your client is at the closing, and someone hands him a check that says $63,000. Do we know what happened? Are there any facts anywhere in the record about, I mean, does he look at it and say, what is this? Is there anything about that?
Well, there is, Your Honor. If you look at my client's affidavit in Exhibit B attached, when he gives his chronology of events with respect to what occurred to the Vice President, because he wasn't getting the $78,000, the restaurant remained closed, he couldn't fund it up because all his funds had been depleted, and at the same time, why would the bank do this, Judge? Well, you know what? If you read my client's affidavit, you'll see, and in the clause of the commitment letter and the loan, they had an ability, Judge, for whatever reason, to escalate the terms and conditions. Well, they did. My client was paying $1,900 a month, which went up to $2,700 a month in the interim. Understand, my client wasn't in default of this loan. He was current in all his payments.
Wait. I'm talking about the day of closing.
Yes.
I assume he wasn't in default on the day of closing. He's sitting in a room somewhere writing his name on things.
Yes.
Right?
Correct.
And he gets $63,000, not $138,000. Do we have any evidence about how everybody reacted to this? Was it a surprise? And so on.
Well, Your Honor, we do, and it's Exhibit B to the affidavit of my client where he's stating to the Vice President at the time what his understanding was at the time he walked into that room, and then to be confronted with, no, this isn't an equity line, this is a construction note.
I see.
And he took the money because at that point in time, and that was my point of going back to give the court some degree of backdrop, he was financially desperate. He was.
No, I get, I mean, yeah, we've read, we get that.
Yeah, so, Your Honor, the issue is this. The issue is the court disregarded or called my client's affidavits, in his terms, self-serving. Implicit in that determination, in my estimation, is the determination that my client's not credible. That would be an inappropriate application with respect to summary judgment. Moreover, Your Honor, I've been doing this for over 30 years. When would I ever submit an affidavit to a court that's not self-serving to support your position with respect to either an opposition or a motion? Of course it's self-serving. It's his case. He knows the facts. He lived the case.
Can I ask you a question about the 93A claim?
Certainly.
Is it pressed below? I didn't see it mentioned at summary judgment.
The judge, at that point in time, Judge, and that was one of my points in my brief, the 93A claim wasn't briefed, and it wasn't argued with respect to the court. The court just allowed the motion on.
Well, I don't understand. So the motion was made for summary judgment on all the claims?
Yes.
But you're saying the brief and memorandum in support of it didn't mention 93A. Did your opposition mention 93A?
I believe my opposition, and I have to look, so I don't want to speak out of school, Judge. I think I responded to the motion that was filed, and if it wasn't in there, I assume that my opposition did not address it. But I would note for the court.
Well, so if it wasn't addressed, I'm just trying to think. All right, so first of all, what's the scope of the 93A claim? How are we supposed to evaluate whether the 93A claim is good or not? Is it about the fraud? Is it about the withholding? Is it about the treatment of it? You know what I mean? Like where?
Your Honor, I was always taught in this industry that when you have a quality fact, you ask the court to look at the facts. But if in this case, I'd ask the court to look at the totality of the situation because it is all of those, all the above.
But where is it? That's in the complaint? I mean, because it's not, if it's not in the summary judgment papers, how is the judge supposed to rule? It's not raised by one side, it's not opposed by the other.
Well, if it's not raised and it's not opposed, Judge, then is it
Well,
proper
not
even before the
opposed is tricky, right? Because you can always put a sentence in that says there is no argument for why the 93A claim should be right, and then the judge can be like, oh, I'm not going to rule on the 93A claim because it isn't, I hadn't noticed that.
Well, Your Honor, during the course of the hearing, and the hearing was a lot of questions being peppered at me with respect to the letter of intent and the like.
We have the transcript of that hearing?
Yes, Your Honor,
Okay,
I believe you
go
do.
ahead.
But the more important thing is when it comes to the issue pertaining to the statement of undisputed facts, I note for the court that the bank, in this particular instance, on my cross motion for summary judgment, filed no response, no answer whatsoever, but it seemed to be completely disregarded.
Wait, your cross motion asked for summary judgment on the 93A claim?
Yes, in all counts.
And therefore spelled out what the 93A claim was?
Yes.
So it's your...
I believe so, Judge.
And that would be in a memorandum in support?
Well, I reviewed my memorandum in preparation for this hearing, and I won't stand before you at this point in time and confirm that it did or didn't. All I know was that when I filed my cross motion, it was with respect to the fraudulent inducement and the breach of contract claim because of the briefs and the issues raised by the bank based on its motion for summary judgment. So when you say the question is whether it was this claim or that claim, my position is this, Judge. My case is that the bank made a loan. They told my client it was going to be a certain type of loan. He went into that meeting to sign those papers with that idea. At the time, they gave him a check, quite right. Did he raise the issue? He raised it in that letter that's attached to Exhibit B.
I'm not saying he had to raise it then. He brought a lawsuit later, right? I mean, but...
Well, because he continually tried to get the money. And at a certain point in time, the bank jacked up their interest rates, and at the same time, and up to the point in time to the judgment entered in this case, still hadn't made the distribution of $78,000, and only made it after they withdrew their attorney's fees pursuant to the court's judgment with respect to their request and motion for attorney's fees. So the only monies my client got, and the only time he got them, was after the bank received its judgment pending this appeal and took and refunded to my client that sum. My position is, Judge, that their conduct with respect to it all and the determination of whether or not my client knew what he was getting into when he walked into that room to sign those papers after he had been led along by for that period of time by the bank led to a significant basis for the fraudulent inducement claim. If I'm out of time.
Well, you're out of time. Are there no further questions? Thank you very much.
Thank you,
We will hear now from Attorney Trainee, whose name I've probably mispronounced.
I don't think so. Good morning, Your Honors. If it please the Court, Rosemary Trainee for Dean Bank. First of all, with respect to the summary judgment portion of this, the judge in the summary judgment made a determination that the plaintiff didn't respond properly under Rule 9A to the facts, the undisputed material facts that the bank presented in its motion. And that was why the judge made the determination that those facts were undisputed material facts for purposes of the summary judgment. The judge was absolutely entitled to do that under 9A. The responses that the plaintiff provided to the undisputed facts were not proper responses. They were things like, it's beyond the scope of this, or it isn't responsive to that. The rules are clear as to how you were supposed to respond to a set of undisputed material facts. But that aside, we have a situation here where we have a commercial borrower, clearly a businessman with experience, makes a statement that the only document he cared about was the note. That's sort of at his own peril, if that's the only document he chooses to care about, because there's a commitment letter. Now, the two commitment letters that are signed on two different dates are both dated the same day. And there's no evidence offered that he didn't sign one on June 1st and one on June 6th.
Okay, can I ask you this? I'm not sure how much it matters when he signed it. I may be wrong about that, but for the moment, where would I look to find the construction loan agreement? What is the construction loan agreement?
The construction loan agreement itself is, there is a paragraph well, according to my brother and according to the plaintiff, in one version of the commitment letter, it was removed.
Okay, whatever, let's assume it's in.
If it was removed?
No, let's assume that the paragraph 29 is part of the commitment letter.
Okay.
Where is the construction loan agreement?
The construction loan agreement only states in here.
Where is the construction, that's a commitment letter. Where is the construction loan agreement?
It would have been, if there was one, it would have been signed at closing.
So there's no construction loan agreement?
If there was not one
Let's
in the
look at
closing.
paragraph 29.
That's correct.
A construction loan agreement will set forth the usual terms and conditions and will stipulate that the unadvanced proceeds will, at all times, be in an amount which, in this bank's opinion, will be sufficient to complete construction in accordance with the plans and specifications submitted to the bank. I take it, therefore, that this paragraph is about what happens when you have a construction loan, as evidenced by a construction loan agreement. You don't have one. I don't see how this applies. What's your response to that?
My response to that is that if you then look at paragraph 30 of the commitment letter, it says that funds for construction and improvements to be held in a passbook account until work completed and be inspected for advances.
Yes, I see it says that. That's 30. It comes after 29.
But if 29 is, as the plaintiff suggests, it was eliminated from the document.
Where would I look to find the schedule of how much money would be withheld and what each construction thing was?
There's no requirement that there be a construction advance schedule.
Well, it does say that it will have the usual terms and conditions. And it says that it will stipulate that the unadvanced proceeds will be in a certain amount. Advances will be made upon the receipt of standard requisitions submitted by the borrower. Each construction advance will be subject to inspection and approval. Sure, if there's a construction loan agreement. But there is no construction loan agreement, and I've read the note. So why isn't this an equity loan, and why did you not advance all the proceeds to the plaintiff when he borrowed the money?
Because the terms of the commitment letter state that the balance of the funds would be dispersed.
Does it? Where does it say $78,000 is that amount? Because I've also read the commitment letter pretty
In
closely.
paragraph 30, funds for construction and improvements to be held in a passbook account until work completed and be inspected for advances.
Okay, but there are no construction or improvement advances unless there's a construction loan agreement.
That's not
All right, so
necessarily.
where do I look? I'd like to see in the note where it says, we are not going to disperse all these funds to you. And I'd like to know where you got the number 78,000 and how you decided to withhold it, because I've looked and I don't see that number anywhere. So I don't understand what it is, and I don't understand why you didn't disperse the full amount to the plaintiff.
The full amount wasn't dispersed to the plaintiff because under the terms of this commitment letter, funds were going to be withheld for construction.
How many? Could you have kept 100? Could you have kept the whole 200?
That was-
Where's the amount? It also says that the release, it says in 29, will be sufficient to complete construction in accordance with the plans and specifications submitted to the bank. Are there plans and specifications that indicate that there will be $78,000 worth of construction?
No, because as the plaintiff says, paragraph 29 was stricken from the.
So you're now agreeing that paragraph 29 is not in the...
I'm not agreeing or disagreeing with him. What I'm saying is that he can't rely on a paragraph that he says isn't there. In his argument, he's
You're
saying,
the one relying on that paragraph.
no, I'm not relying on it. I'm relying on the other paragraphs in this document that talk about the fact that.
You think
they
funds
can
for
withhold-
construction and improvements to be held in a passbook account until work completed and be inspected for advances, which is a system that's described up above in a construction loan, you think that you can withhold funds for construction improvements.
I can't.
How did you calculate the amount?
I think that was calculated at the time of the closing, and
How?
it was on the closing statement.
How? How was it calculated?
The bank would have calculated it.
With what? Based on what?
Based on what the borrower provided to the bank as to what work the borrower was
Plans
going
and
to do.
specifications submitted to the bank?
They may not have been formal plans.
Is that how your bank does business? You just withhold some amount of money, there's no formal plan. We think 78 grand should do it. I've never heard of a loan like that, and I don't understand why the bank has used what looks clearly to me like an equity loan note if you're making a construction loan.
Well, I will say there are a lot of different types of notes. I don't believe that the way I view an equity note
Yeah.
is like a revolving note.
No, a mortgage.
No, well, an equity note in the way that I view an equity note.
Mortgages are, I'm not talking about an equity loan, a home or other equity loan. I'm talking about a mortgage based on the equity in the property. That's what the note is. It gives you a right to foreclose on the property. You have guarantors, and you're going to give them $200,000, and you didn't. And I don't know how you came up with $78,000. I honestly don't. And I don't know why you're allowed to just come up with it out of thin air.
As I said, I don't believe that. I think I think we're focusing in on one document and not on the
I'm
totality.
focusing on both documents, the commitment letter, which is not part of the note, and the note.
The commitment letter that.
It is
that-
not part of the note.
It-
Let's look at the note.
It is not part of the note. However, the commitment letter does contain a provision that says that the terms of the commitment letter survive and continue on with the closing, after the closing, and that if there's a failure to comply with the terms of the commitment letter, the commitment letter remains enforceable. It says, in the event the borrower fails to comply with any terms and conditions contained herein, or fails to provide the bank with any of the information requested in form and substance satisfactory to the bank and bank's counsel, the bank shall have a right to withdraw or modify the within agreement. That's in the commitment
Did you
letter.
withdraw from the agreement?
They didn't disperse the remainder of the funds. Because
How
he
did they get, I'm sorry, I just don't know, you keep calling this $78,000. How did you pick $78,000? How do you know how much the rest of the construction's going to be? By the way, I think you were charging him interest on it. I think you were
didn't do the
charging him
numbers.
interest on money he didn't get that you could have still invested. Do you think bank regulators would be pleased with that?
There's a provision, Your Honor, that if the funds are placed in a separate account, which these were, they were placed in a passbook account.
In the note it says this?
Excuse me?
Where does it say that, in the note?
It says it in the commitment letter.
Show me where.
It says in the commitment letter that the funds will be placed in paragraph 30.
In a passbook account?
Right.
Okay.
It says that the remaining funds will be placed in a passbook account, and so therefore the funds are segregated.
I
They
don't
are
see
not-
how, without something setting out and you guys agreeing on the amount that are the funds, I just don't see how you can pick out of thin air a number and withhold it.
I don't think that the number was taken out of thin
Okay,
air.
tell me where in the record I find how you reached it. Because I don't see anything that he signed that says anything about this.
I don't know whether or not, and I apologize, because I don't have the record in front of me, but there's a settlement statement that is signed at the closing, and the settlement statement would have designated the construction holdback.
Let me see, where is that?
I don't know if it was included in the record appendix. I would assume it was. It was one of the documents that was executed at the closing. And that's typically where the disbursements are
Well, that's
noted.
typically where each of the things described in the note are placed. So if you owe taxes or they owe taxes, it goes there, right?
It's more
I
than
mean,
what's...
it's not just we've made up a number and put it here.
No, it's not, but it's also the numbers that go beyond what's in the note. It's typically, it's closing costs, it's bank fees, it's things that are
But
not
there are
necessarily in the
agreements
loan.
about those. The borrower signs agreements about which lawyer is going to represent them, will it be deducted, or you'll pay for it. Right, I mean,
yes.
obviously, you have to have agreements before you give or withhold money.
That's correct. That is correct. And I believe, Your Honor, it's certainly our position that the commitment letter is a document that's executed as part of the loan documents.
I don't know what that means.
Well, you're bound by the loan documents that you signed,
Sure,
in addition to the note,
sure.
mortgage, whatever other documents
If
you
this
signed,
thing said we're going to
guarantees.
start with the withholding of $78,000.
That's
Then
correct.
I'd say, okay, it doesn't say that. You unilaterally get to decide what the funds for construction are? That's a pretty, you think yes?
Very often banks do make the decision as to what they're going to hold.
And they
for
don't put it in writing?
It was in writing in the settlement, in the closing statement, because he was dispersed a certain amount, and the balance was withheld.
Sorry, I just don't understand. How's he supposed to know when he's borrowing it? He just gets there and you give him a closing thing and say 78,000? We thought about 80, but then we decided, no, let's deduct about
When he got
1,600.
there, he would have gotten a closing statement.
Yeah.
The closing statement would have shown a construction holdback on the closing statement. Whatever that number was, if it was the 78,000 that we're talking about.
Okay.
He would have gotten dispersed a certain amount at closing, and the loan was for a certain amount.
Well, look, if you point me to a document like that so I can see what we're talking about, I guess. I mean,
there would have been-
that seems like a pretty unusual way to announce you're not getting a third of your loan, even though you're going to pay interest on it.
Well, again, if he was getting money for construction, which he claims he was getting money to do work.
I'm sorry.
He was getting money to do work on the property.
No, the note says he's getting money in exchange for mortgage on the property.
That's correct. But he
Okay.
was getting money to do work on the property because...
Or for whatever other reason he wants to use it for. He's just got a new mortgage.
Well, no, because he's got a commitment letter that says that there's money that's going to be held.
No, it says if there's a construction, I mean, whatever, I have to look at it.
No,
You may be right. I don't mean to say,
No.
I have to look at this more carefully. But to me, there's all this talk about the commitment letter, and then I was surprised when I looked at it particularly since, at least in your brief, you rely on paragraph 29. I understand he says it's not there, and you say, well, in any event. But paragraph 29, to me, does not authorize anything unless there's a construction loan agreement.
That's correct, but my only point is that if he's saying you can't rely on paragraph 29, and he's saying that because paragraph 29 isn't there, the whole thing goes out the window, what I'm saying is that there are other provisions in the commitment letter that allow the bank to withhold construction funds, and that was what the purpose of this loan was, and that he knew that when he signed the commitment letter. Even if you want to take out paragraph 29 and give him the benefit of the doubt that paragraph 29 didn't apply, there are other references in the commitment letter to construction financing, and that for him to say he didn't know, he didn't understand, he didn't read, all he cared about was the note, and he didn't look at the commitment letter, he's still bound by the terms of the commitment letter. And that's what I'm saying, is that you don't ignore the commitment letter. Give him the benefit of the doubt that paragraph 29 was intended not to be in there. And that at closing, there's no mention in his brief whether he signed or didn't sign a construction loan agreement at closing. So I don't know the answer to that question.
You think he did sign a construction loan agreement?
I can't
How
say-
can you get summary judgment without showing it to the judge?
I don't know, I was not trial counsel, so I don't know all the documents that were presented, but they're in the record as to what was presented at the summary judgment.
If we find or conclude that the affidavit of the plaintiff should have been considered, is there a material fact in dispute?
I don't think that there is a material fact in dispute, because even with the affidavit that he submits, you have to look at what the actual statements were in the affidavit. Yes, whether or not they were self-serving. I understand what my brother's saying. Everybody's affidavits are self-serving to a point, but they also have to be relevant to it. And I think that perhaps the judge's determination that they were self-serving may have been a little bit unclear, but I think it was more that what was in there wasn't relevant to the issue as to whether or not there were any facts in dispute that were relevant facts, material facts in dispute. And I think that's what the judge was focusing on, using the documents and the information that the bank had provided to which he didn't respond properly. And I think that's how the judge looked at it at the summary judgment level.
Right. Going back to a question that Justice Rubin asked opposing counsel, nowhere in any motion or any opposition that I can find is 93A even referenced. So how do we deal with that? First of all, again, a lot of facts, a lot of documents. Would you agree that that's not referenced anywhere?
I did not see it referenced anywhere.
All right. So what do we do?
Not to put my hands back and abdicate, but I think that it would have been on the plaintiff to present it at the summary judgment stage if in fact it was a claim that he was advancing.
I'm sorry, you moved for summary judgment and didn't mention it. Why should summary judgment be allowed? Your motion was allowed, but it doesn't refer to the 93A claim, so shouldn't it have been partial summary judgment on these other claims?
If that's what the judge had viewed, I don't remember specifically in the transcript if they argued that at the actual summary judgment hearing. But there was also a cross motion for summary judgment, and on the plaintiff's claims where the plaintiff was advancing their claims. So, and I don't believe it was raised.
The transcript is in the appendix somewhere? It might be. Again,
I believe it's in, I don't know if my brother submitted it as part of the appendix.
I believe so, Judge. It was part of it. That's what we're waiting for.
I think it's in here. I think I saw it. All right, your time has expired, but I took all of it, so
I'm all set.
all right.
Thank you.
Thank you very much, both. The case is submitted. And that brings us to the end of today's sitting. I'd like to thank the court officers and the court staff for their excellent work today. And we stand in recess.
All rise.